Well, thanks for watching Market Day Report. Good afternoon. I'm Suzanne Alexander. Thanks for staying with us. Well, yesterday, the Supreme Court ruled to limit EPA's authority to regulate power plants' greenhouse gas emissions. Now, the move presents a major hurdle in the administration's plans to address climate change, leaving many speculating over the potential impact for agriculture. Roger McEowen with the Washburn School of Law joins us now for further insight. Roger, as always, thanks for being here. And, we've touched on this issue in the past. So give us a little background on this matter.
Well, this is a really important case. This case arose from President Obama saying early on in his first term that he would put coal plants out of business. And from that, the EPA created the Clean Power Plan rule, addressing CO2 emissions from coal and natural gas power plants. And the EPA cited their authority granted purportedly to it under the Clean Air Act for doing that. And the plan set rules for burning coal more cleanly, but then also it involved a regulatory shift in energy production from coal and natural gas electricity generation to wind and solar. And so the EPA projected that electricity generation under this new rule from coal would decrease about 30% by 2030 from 2014. And they also noted that no existing coal plant could achieve the new standard without shifting to wind and solar, which would trigger billions of dollars in compliance costs, increase consumers' electricity prices, require dozens of coal plants to close, and eliminate tens of thousands of jobs.
When you look at this and how the court decided, how did they come to this decision?
Well, the basic issue in this case was whether the EPA had the authority to shift the manner of energy production in the United States by regulation. The court said it did not because the Congress had not specifically stated in the Clean Air Act that EPA could enact such a policy change by regulation. The court said that EPA could regulate equipment upgrades, they could regulate the improving of the operating practices of a plant, electricity generation plant, but it couldn't shift the entire means of U.S. energy production by fiat, by regulation. That's up to the Congress to do that, the court said. It's a policy issue to be decided by elected representatives.
So this decision, I would imagine that it's going to have an effect on agriculture overall. Talk about that.
Oh, yeah. We've been waiting for this decision in agriculture for 2 or 3 decades. The decision clearly lays the groundwork for further limitations on regulations from all administrative agencies, including USDA, in the absence of explicit congressional authorization when a major issue is involved, such as, for example, waters of the United States.
Mm-hmm. So you really do see this decision kind of setting the stage for other regulations moving forward and really the world of agriculture really benefiting from the overreach on many other departments.
I really do. The major question doctrine is an exception to the general rule of deference that the courts would normally give to administrative agencies. Now, when an agency gets into issues of major national significance, they don't have the authority to regulate. It's up to the Congress to make the policy decisions, not administrative agencies. That's the way the founders set up our system.
Do you see other issues now coming to the table with other going, hey, wait, this has set this precedent. Let's now go and tackle this next issue?
Well, we could see this with respect to certain SEC regulations. We could see it with some of the COVID restrictions that might still be out there. Do these agencies still have the authority to do that when you have a major national issue, a major question? This is the major question doctrine involved. And the court is clearly saying, no, administrative agencies, that's up to the Congress unless they clearly delineated that in a statute delegating the authority to you to do this. You don't have the authority.
Absolutely. Great information, as always. Roger McEowen, thank you so much for being here, of course, with the Washburn School of Law. Always appreciate your time.